Well, good evening, everyone. May I commence by acknowledging the traditional owners of the land on which we are meeting tonight. I pay my respects to them. My name is Lindsay Howes, and I am an adjunct associate professor at this law school, and I teach insolvency law here. And I'm also a consultant to Medra Ellison, where I was a partner for my sins for about 30 years. I'd like to welcome you all on behalf of the Ross Parsons Centre for Commercial, Corporate and Taxation Law, and also the Association of Independent Insolvency Practitioners, who made tonight's presentation possible. The AIIP has also provided a foundation tonight by commissioning Professor Harris to prepare a report on the submissions that have been made to the Parliamentary Joint Committee inquiry on insolvency law, which Dr. Harris will draw on tonight. If you've registered via email, you'll receive a copy of that report tomorrow. Our speakers, Dr. Jason Harris and Michael Murray, really need no introduction to insolvency practitioners. The authors of the leading text on insolvency law, Case Insolvency, now in its 11th edition, and a 12th on the way, I believe. Jason is Professor of Corporate Law at this university. He teaches and researches in the areas of corporate law, insolvency law, and Jason's research is focused on public and private regulation of financially distressed companies, including debt restructuring, voluntary administration, and directors' dues. Jason's research is frequently cited in Australian courts, including the High Court of Australia, and Jason is an active participant in law reform initiatives. He does work with the Governance Institute of Australia, the Australian Institute of Company Directors, and the Corporations and Insolvency Committees of the Law Council of Australia. Jason is a Fellow of the Australian Academy of Law, a Fellow of the Governance Institute of Australia, and an academic member of Insol International and Eureka. Michael Murray is an insolvency law author and commentator. He authors a website which covers insolvency law thinking and reform, which has very wide local and international readership. He also writes for Ford's Corporation Law and the Australian Business Law. He co-edits the Insolvency Law Bulletin and other insolvency-related publications. He's a Fellow of the Australian Academy of Law, has qualifications in law and criminology from the University of Sydney and in insolvency from the University of Southern Queensland. He was formerly the legal director of Eureka and a member of the Corporations and Markets Advisory Committee, and he was also a solicitor assisting on the HIH Royal Commission. Tonight's format will largely follow what I'm about to announce. We will first hear from Jason and Michael about the background to the PJC inquiry, and they'll give some general comments on what they learned from their participation in it. We'll then try to go into a little more detail on some of the areas that the committee has focused its attention on. And I'll do that by raising some questions with Jason and Michael to hear what they've got to say about that. And I'll also invite any questions that you here might have on the topics as you go. And also for those who are attending online, you can also raise questions via Zoom, and we'd ask you to use the link for Q&A that appears on your Zoom screen. And we're aiming to finish by about 7 p.m. So, Jason, over to you.
Actually, I'll pass on to Michael first, okay. Then I'll get.
Thanks, Jason. Thanks, Lindsay, and well done.
Just Michael. Should already be on.
Well done, Jason and team, and the AIIP in terms of producing that report, which we're talking about tonight. I'll be making some comments throughout as needed, but I'd like to make some opening comments about the inquiry itself and about the submissions overall. Let's say I've been around for a few law reform inquiries over the years, even going back to the tail end of the Harmer inquiry. As a matter of history, that inquiry took pride in the fact that it went on circuit around the country seeking views on the reform of the then insolvency laws. While this 2002-2003 inquiry did come to Sydney, nowadays, of course, much input is given by email and online. In the end result, it generated a large number of submissions from around the country, close to 80, I think it was.
78. Yep.
78. And then, as I'll explain, a lot more responses to questions on notice, resulting in a huge amount for Jason and the team to get through to produce the very good document that we have before us tonight. I will say that this is the best insolvency law inquiry in which I've been involved, and I've been involved in some good ones. Anyway, for a few reasons. Committee members themselves and the chair were very committed, interested and personable to deal with and to appear before, with an excellent support team behind them. I say that also because some inquiries in the past have seemed to me to be rather mechanical and perhaps too focused on particular issues. This committee was very open in its thinking, and the committee members asked well-directed questions and were ready to engage in any necessary discussion with those presenting. Anyone who needed to respond on notice was readily given permission to do so. And in the end result, as I said, a very large number of questions on notice and more besides were issued. And the submissions, I thought, were very good and from a wide range of perspectives. I express this view, obviously, without having seen the committee's report, which we expect to see next week, but I assume it will be of a high quality. While there's probably not much point in anticipating what the committee itself might say, I myself would like to give a view on the submissions as summarised in Jason and his team's report, in the context of my reading of some of the views expressed by the committee. When I read the report Jason and his team have prepared, I was struck by the fact that while many of the submissions are thoughtful and address the detail of insolvency, the larger issues as to insolvency's purpose and what it can achieve are not there or not at the forefront. It is all very well to talk about preference law and recovery rights and investigation processes of liquidators and such, without settling why those remedies and processes are needed at all, why we have an insolvency regime and to what it should be directed. I say this in the context that, as we know, and as the committee focused on, most insolvencies are in the SME market, and using some broad brush figures, over 90% of liquidations produce no return to creditors. Upwards of one third of administrations, according to ASIC, are unfunded. And there are so many breach reports given to ASIC as to be nonsensical. That is not to forget that there is still a substantial body of work that does need insolvency's close attention. Now, the committee, as I said, I thought was very good. One positive feature of it was that it was not well versed in insolvency. And I say that, of course, without any disrespect. But I saw that, in fact, as a positive in the sense that we got a fresh outlook from a body of very interested and experienced people from outside insolvency as to what insolvency was about or what they expected it to be about. That then led to some rather direct questions as to the fundamentals of insolvency, very fundamentals of insolvency. And I'm not sure what Jason said to prompt this line of inquiry, but when he and I were there before the committee, I think Jason had mentioned the number of companies that didn't go through the insolvency process and went through the deregistration process. And the chair said, and I'm just reading from the transcript, bring it right back to the terms of reference for me. Most Australian businesses that shut up shop have nothing to do with insolvency, to which Dr. Harris agreed. The chair then said, what's the benefit of cleaning up your affairs and going through the process of solvency? What is the public and private good of that? Because that's the part I'm really starting to question. I understand the principle of it, but in terms of its practical machinations at this point in time, I don't understand that. And then even later on in the inquiry, after the committee had taken a fair degree of evidence, and this I think was when Arita was there, the chair responded to comments from Arita about the committee's serious concern. What does the creditor get out of this whole system? What is the public good of having this model operating? I understand it's functioning, but something just feels really incredibly wrong about it. Now, that then led to, as I said, there were quite a number of questions on notice, and we got our fair share. And one of the questions we got, and probably others did as well, was what are the goals and purposes of Australia's corporate insolvency laws? Do you think those goals and purposes are clearly articulated? Are they in turn adequately realised in practice? Have the goals changed? Are the goals and purposes themselves adequate and appropriate, or may they need reform? And that was a bit of a theme in those comments and also other comments made by the committee in my exposure to the, when I was there, I should say. I haven't read the whole transcript. That was a bit of a theme that was raised. Now, one tentative view that I might have, and I know it's a bit radical, as to rethinking the purposes of insolvency, is to lessen the attention that the purposes of insolvency give to unsecured creditors. Unsecured creditors receive not much at all, if anything, in insolvency by way of a financial return. As much as they can expect is some accountability for their losses. I would say the main purposes of insolvency nowadays are the protection of the debtor and the release and their release, a tidy up exercise, which can be quite substantial, as we'd know, depending on how the company is left at the point of insolvency, and some limited accountability. Insolvency may need to reduce creditor expectations. To reduce, I think we refer to this in the book, Jason, to the expectation gap as to what insolvency can achieve. This is not to lessen the importance of insolvency, but rather to redirect and refocus its efforts. Now, there is a counter view, and this is another interesting exchange on that very point that Rita had with the committee, and I think with the chair. And it was John Winter speaking, and I thought he made some good points. He said that Australia has a very heavy focus on creditor rights. That's culturally where we sit. Our entire system of trade credit is based on that. If we're going to shift that thinking, we're going to have to shift the way we do business entirely. And the chair said, Mr. Winter, you're not suggesting that we begin the process of lowering Australia's expectations about creditor rights, I think she meant. And John Winter said, of course, not at all. The chair went on to say, I want to just be clear that is our cultural expectation. We have still not lost sight culturally of our aspiration to have a better system to make sure businesses keep trading and people get paid. So there is that, contrary to what I was saying about maybe we need to lessen the focus on creditors, there's that other point of view, which I very well understand and respect, that creditors are what insolvency is all about. I just thought I'd mention some of those broad issues which appear, I think, somewhere in some of the submissions at times, but maybe not to the forefront. When we were reviewing all the documents that Jason, or the submissions that Jason is about to take us through, about some overarching concerns that the committee had. I should, whether the committee deals with those or, as I might anticipate, says that these are matters for a more broad brush comprehensive inquiry as to readjusting the purposes of insolvency, we'll just have to wait and see. But one thing that she did ask Rita on notice to provide, which is again indicative of the thinking, when the chair was saying something doesn't feel right about all this or incredibly wrong, She asked Rita to provide a really in-depth understanding of how the business model that you're operating actually works, what the costs are, what the benefits are, and what changes could occur. I think the operation of the whole system is something that the committee is looking at. And I don't say that that's not covered in the various submissions, but it seems to be an overarching thing that when you're looking at any particular submission, that overall concern of the committee should be kept in mind. Thank you.
Thanks, Michael. I just had a few comments to that and basically echo everything Michael said there. I was certainly very impressed with all my dealings with the committee in terms of when Michael and I appeared before them and in our correspondence, and as part of this project, generously supported by AIIP. I have been through all of the submissions, all of the transcripts, all of the answers to the questions on notice and supplementary documents, together with the fantastic students that I had helping me here from Sydney Law School. And it seems clear to me that the committee, unlike some previous committees that the insolvency profession has dealt with, that this committee does not seem to be coming to the task with a predetermined outcome, that they seem very open to hearing different perspectives from different stakeholders in the insolvency system. And that was certainly very, sorry, I did put this on silent. That was certainly very refreshing compared to some earlier committees where we had particular members of Parliament who clearly had very specific goals in mind when they were convening some of these committees. So I think that opens up really a broad range of potential outcomes coming out of this report. I expect that we will see some perhaps minor changes recommended because the committee was asking people who were appearing before it, okay, you've talked about these big thematic issues, but kind of what are some quick wins? What's some low-hanging fruit that we can do to try and improve things? So I think we might see something coming out of that, which we'll talk a little bit later about. I'm reasonably confident that we will see a recommendation for a broader reform because that was really the consistent message across almost all of the submissions. Whilst there were some who said, look, the system isn't fundamentally broken, but it has been literally decades since we last did a big review. The economy's changed, business has changed, the asset model of business has changed, the credit model has changed, and it probably is time for a wholesale review, whatever we want to call that, root and branch wholesale reform. So I think we will see something on that, and I'm really looking forward to see how the committee works with the various submissions. Just in terms of the background for the report, so what we've tried to do with the report is we're not pushing particular reforms that we think should be introduced, but rather what AIIP asked us to do was really try and get our head around all of the various views that were being presented in the different submissions. So when you get access to the report, which should be sent through sometime tomorrow, you'll see that we really tried to summarise what the different views were without necessarily saying this is what we need to be doing. Now, I will, as an academic, be writing an academic paper on all of this, so that'll come out probably later this year, and you'll see very clearly what my views are. So that's just my general comments. I'll throw it back to you, Lindsay.
Thanks, Jason. On the question of the wholesale law reform issue, I must say when I saw the terms of reference for the PJC inquiry, I was just astonished to look how broadly they were going to penetrate into corporate insolvency law. This is a committee that's constituted, I think, by virtue of the ASIC Act.
Yep.
And therefore it is principally focused on corporate insolvency. But of course there is the whole range. I know we've got a lot of interest from practitioners who are in the personal bankruptcy area, which is another area that is requiring a considerable amount of attention. So I'm confident that from what Jason and Michael have been saying, we are perhaps on the verge of getting a recommendation for a much more wholesale review of insolvency law in general. I certainly know when Mira Ellison put its submission in, we were emphasising possible need for a single statute. After all, it's all Commonwealth law. We could have a single statute now that regulates corporate and individual bankruptcy, which exists in other parts of the world. So perhaps we'll see something come of that, but I would doubt that we would see anything being recommended until there has been a much more thorough investigation of the personal insolvency side. One issue I think a lot of people will be interested in, Jason, is the role and responsibility of insolvency practitioners, and what was being raised before the committee there, and what sort of appetite you think they've got to make recommendations in relation to things like reporting, independence fees and the like.
Yeah, thanks, Lindsay. Again, with this, the impression that we both had of the committee, that they were fairly open. We certainly had the impression that the committee wanted to really understand how insolvency practices work, what sort of obligations they have, what their cost structures look like, and of course what the law requires of them. And there was a broad sense in the submissions that the keen stakeholders in insolvency, the kind of regular participants, the tax office, major creditor groups, for example, law firms, that there was a good understanding of the various obligations that insolvency practitioners have. On the other hand, some of the smaller creditor groups, and certainly some of those who were representing employees and contractors in the construction industry, for example, seem to express both in their submissions and also in their appearances before the committee that they didn't fully understand exactly what it was insolvency practitioners did. And for example, some of the small business groups were representing their small business members. And as many of you would know, the Federal Small Business Family Enterprise Ombudsman did an insolvency practices inquiry a couple of years ago, and that came out with some interesting recommendations, some of which Michael and I have then given support to as well. But it's very clear that, say, some small business people, for example, feel like insolvency practitioners don't understand their business and that they're getting poor outcomes. Now, on the other side of that equation, it was also very clear from the submissions from insolvency practitioners that, and also from lawyers and some other groups, that often these small businesses, we might say almost always, these small businesses are leaving things till the last minute. And so that frustration with feeling like they're not getting much out of the insolvency system, both from the smaller trade creditor groups and also from the small business groups, and there were a couple of individual submissions from business owners, feeling like they're not getting much out of the system, feeling like they are losing control of their business, which of course they are, that's what the law mandates, but then also not really understanding the range of obligations that insolvency practitioners are under, the things that they just have to do because the law requires them to do that. So one potential outcome from that may well be, and some recommended this, and certainly the Federal Small Business Ombudsman recommended this, that there does need to be better information and more accessible information to some of those groups so that they have a better understanding of what it is that insolvency practitioners do. Now, Michael and I both know that many insolvency firms have developed some fantastic letters and information packs that they send out to creditors to try and explain things. If people don't read correspondence that you send them, there's not much you can do with that. But there also was a lot of talk about really the role, or rather the lack of the effective role of ASIC in that equation, that ASIC as the relevant regulator here could do more in terms of facilitating better information to creditors and other stakeholders. They do, of course, have an insolvency section on their website. I must say, and I said this to the committee as well, the website of ASIC is very difficult to use. I don't know if the liquidators portal is any easier than the general website, but the general website is not very usable. So the ability of stakeholders who aren't sophisticated repeat players in insolvency to access some of that information, I think, is very limited, and we could see some recommendations coming out of that. In terms of the responsibilities of insolvency practitioners, the committee did seem very interested in the investigation and reporting obligations. And I'll be interested to see whether they want to leave that to a more general inquiry to actually go in and have a look at all the various reports and various investigations and forms, or whether they're prepared to come out and make a recommendation. I certainly got the sense from some of the transcript discussions that they might recommend that insolvency practitioners shouldn't be doing some of the things that they're currently doing now. Now, on the other side of that equation, of course, we have the groups representing insolvency practitioners and also ASIC and some of the other regulatory agencies who basically are saying, well, these are very important public interest functions that insolvency practitioners perform, and maybe what we need is actually a better funding system for that. So it's not the case necessarily that we just say, well, you're not getting paid on these jobs, so stop doing those jobs, and those companies will just get deregistered. Rather, maybe what it's saying is we need a much better funding model. Now, on the funding side of things, there was a whole range of different suggestions. One of the most commonly recommended suggestions, mostly from insolvency firms, I must say, was to follow the AFSA model in personal insolvency. So rather than having the current funding model that we have now, have a model which is based on some sort of, realisation charge, for example. That also ties in with the industry levy that insolvency practitioners, corporate insolvency practitioners, have to pay to ASIC each year. And there was certainly a lot of discontent about that. I mean, some firms described it, and I think it's an apt description, as a tax on insolvency. So there was a big pushback to get rid of that, have a different funding model. There was, by and large, wholesale disdain for the assetless administration fund. I don't recall seeing a submission that said this is a really great system and we should keep using it. So multiple submissions said we should scrap it. A number of submissions said we should completely redo it. And a lot of insolvency practitioners complained about the fact that it's very complicated to use. You never get enough money to do the job that you actually want to do. Some practitioners said that essentially you almost need to have the information that you're trying to get the funding to find in order to fill out the relevant forms, and that it costs you almost as much money in work in progress time to complete the process as you're going to get through the funding. So it just seems to be a pretty broken process, and certainly is nothing what the Harmer Committee was recommending when they recommended something like that.
Well, Jason, on a related theme, perhaps I could throw this question to Michael, and that is the concern about the process and who is doing the work. Was there any discussion or submission concerning the idea of a model where we have something like a government liquidator, where the whole process can be, at least at the option of perhaps a creditor, handed over to a government liquidator to conduct the process?
Well, Lindsay, that's something that Jason and I have raised, and as I've said, those interested in the history of it, Australia was always intended to have a government liquidator, an official receiver at the time of Federation, but for various constitutional reasons it never eventuated. England has one, and so does New Zealand. And in my view, the purpose of that would be to deal with the fundamental inherent issue in insolvency, that many insolvencies are assetless or have limited funds, and for the private sector to be expected to administer those is not realistic. Having said that, I think Jason probably raised that in our submission, and some others might have as well. I noticed there were a number of submissions against that, or certainly Arita put up another, 4 or 5 or 6 or 7 reasons why that should not be the case, that it should be left with the private sector, but with some expectation of funding. I didn't ultimately get a clear view from the committee itself what it thought of that. I mean, it's a very big issue as to what, how I would describe it as a public interest issue being dealt with by the private sector, and insolvency itself is not alone in that sort of tension existing. I don't know about you, Jason, but get a feeling for the committee as to which way they might go on that. It would be a very big call, I think, for them to suggest that or recommend it. I think that's something that if it were to be on their agenda in the final report, they would say that would be best left to a more broad brush, comprehensive inquiry.
I'm just wondering, perhaps opening up questions whether a lot of practitioners here, is there any appetite amongst the profession to see this, particularly the work that is expected to be done virtually for charity, for that to be quarantined away in favour of a government administered service? Do people
don't make it a charity, just pay.
Sorry?
Don't make it a charity, just pay.
Yes.
Because there's going to be a level of overhead the government will bear. They can't make the same decisions, trade words don't work.
So the idea would be to provide more funding for private trustees and
absolutely.
To do it. Yeah.
Take the charity nature away.
Yes.
I think that the government would not be interested in giving fresh funds to do that. But if it was coupled with a drawdown on the realisations charge, so it's a net effect for the government is not not an expenditure, it might be a bit more palatable to the government to do that. And if it wasn't, the current AFSA system for bankruptcies is that the government public servants triage or screen each job. And if it looks like there's a hint of an asset, they then give it to a trustee. And I think most trustees think that's a pretty good system. So all the jobs that have completely no hope of ever having any asset realisations remain with the public servants, and the potential funds go to the trustees on a rotation list.
Thanks for that. There's another question.
How would you see all of a sudden if you coverage before they sort that out? So why not just take the realisation and pay us to do it?
Yeah, I think that's the better view, but the government does not want to have a net outflow of funds to fund private practice to do something. But I know what you're saying, but the public servants have been pretty good at looking at the totality of a bankrupt estate and working out there is something here. Now, how they do that from a statement of affairs that a director submits, that's got to change. It's got to be a bit more information before you put your company into liquidation. And that might solve the problem. The government. Well, AFSA have a budget based on the realisation charge. And they draw down the budget. So there's no net effect on the government. So if the government...
There's certainly obviously a considerable amount of work to be done here if we are going to follow that model to just work out, you know, and selling it to the profession and to the public at large. After all, there is still the expectation that the process that's being undertaken is being a thorough one conducted by skilled people in the area and not handed down the chain to some government department where there might not be sufficient levels of expertise or interest. Was there any other? Yes, Anthony.
Hi, Anthony Warner here. I'm a Liquidator Plus trustee. Just going to pick up on what Steve's just said. We see firsthand what AFSA does with the official trustee model, and that for people that aren't familiar, that's where bankrupts declare their bankruptcy with the government, and the trustee is meant to do their job. We see some cases where bankrupts go through that system and never hear from the trustee. So AFSA just doesn't do anything. So in terms of public confidence, what is that going to promote? So if we do that for liquidations, you'll have company directors that, you know, strip assets, do phoenixing, you name it, goes to the government liquidator and nothing ever eventuates.
Michael, did you have a comment on that?
Going back to the points I made earlier, and I'm not purporting to speak on behalf of the committee, of course, but that view that was expressed about what's the purpose of all this. The official trustee, I think, produces something in the order of 1 cent in the dollar by way of dividend. Registered trustees produce 2 cents in the dollar. Someone might say, you know, what does it matter who administers it? It's not a big issue.
Can I just add something further before you respond? My comment on that would be that, you know, coming back really to Michael's very first point, but what are we actually trying to achieve in insolvency here? Because I completely take the points that you're making, Anthony, about creditor confidence and the value of having a highly skilled and experienced insolvency practitioner who can, you know, somewhat efficiently get to the heart of the issue and, you know, work out where assets are and reconstruct books and all of those types of things. But what we're also hearing, both from the profession and from creditors and through these submissions, is that in large numbers of these matters, there's not the funds to do that. So I guess my response would be, we're already living in that system because creditors know that in the vast majority, particularly of the smaller jobs, there's not going to be a return. There's not going to be any enforcement. And insolvency practitioners are complaining, and justifiably complaining, that they're sending literally thousands of offence referrals to ASIC every year, and ASIC does almost nothing with them. So I would say we're already living in that system.
Well, that's true. ASIC very rarely takes action, which frustrates all of us. But They are reasonably effective on the fringes, like in terms of director banning. So that must promote creditor confidence that, you know, if these directors keep on dumping companies, that they're going to get banned. So, you know, something's happening. It may not be enough, but something is happening.
Yeah.
From that compliance point of view.
And on that banning point, it's quite interesting. There are a number of submissions about director disqualifications and penalties against directors. So there were some who said, effectively, you know, if a company doesn't have assets when it goes into insolvency, that's the director's fault and they should be responsible for that. Some recommended increasing the penalties on directors, you know, or perhaps requiring directors to pay a percentage to creditors. So there were various suggestions. Many people suggested that we needed a better and more effective and stronger disqualification regime, and I would completely agree with that. On the director banning point, I agree with you that ASIC is taking more action. So, for example, on the Phoenix side of things, a lot of people criticised ASIC in relation to Phoenixes and said, oh, you know, Phoenix is rampant in the economy. And some people were saying, well, ASIC does nothing on this. One of the other roles that I have is to do an annual review of corporations law for one of the publishers. And that actually requires me to go and read all of ASIC's media releases each year, which I do in December. And I've been surprised over the last couple of years, they are actually taking more actions than what they were a few years ago. However, I'm also working on a research project where I'm looking at ASIC enforcement statistics over the last 26 years, basically going through all of their annual reports where they report these things. And ASIC is banning roughly the same number of directors that it was banning about 20 years ago. So they are making some inroads, but overall, I would not be confident that there's an overall lift in enforcement activity.
Jason, just on that topic of...
Sorry, Lindsay, I think there might be a question on Zoom.
Oh, yes, we've got two online questions. Okay, yes, I'm going to repeat the question. Somebody's asked the question to repeat it, which I will do so. Is that it? Okay, all right, I will certainly do that. Thank you for pointing that out. I was going to follow on from the last comment you made, certainly in relation to statistics, and that relates to the reforms that were introduced in 2021 and the publication by ASIC of a report earlier this year. It's report number 756. And they were looking at particular in relation to restructuring. And it undertook a review of all of the appointments of small business restructuring practitioners through to the 30th of June last year. There's some interesting statistics. There were 78, I think there were 82 in all, involving appointments of small business restructuring practitioners. So when you think about that, that's not a big number, particularly having regard to the fact that we see voluntary administrations in almost tens of thousands. Nevertheless, it's a relatively new procedure. Sort of question?
I'm a liquidator in that way. No, correct you on the mistake, where I think things go. I think they're becoming more popular. Practitioners will understand them. And now in the suitcase, they're offering will hit. And just today, we pointed out about 60 more policies. So it's interesting in that space.
Yeah.
And there was something in there that the first thought was especially the president of our thing, we thought it was our group that we think they were going to hold traction, but I think that they're going to be popular and they're going to say. And can I make a comment about insolvency laws? Insolvency laws don't appear in their own bubble, that banning directors should also be related to the activities that they're doing. And I can quickly go to an example of property developers. New South Wales, they go, any number of jobs will go into liquidation. You go to Queensland, they just get one and they're banned as being a builder. This SPRP is an interesting loophole perhaps for Queensland builders to avoid that sort of automatic cancellation of the licence. So when you talk about regulatory drawback on having a company go into insolvency, the industry itself and the other regulatory bodies can bring to an end the careers of some of these operators. But the statistics for SBRPs, I think, are looking really interesting. The more and more practitioners are picking them up, and they're being priced better now than they were before. And I don't think that they're going to go away. They're
certainly, and those figures that I was giving you were only up to the 30th of June last year. Perhaps we're seeing now that we're getting over the COVID sort of malaise, and we're seeing more activity in relation to debt recovery. But I thought that one of the interesting statistics was that they reported that the median cost of a small business restructuring process, including a plan, was $22,000.55. Now that's considerably cheaper than any voluntary administration I've ever been associated with. So that's obviously a good thing. Jason, was there discussion of this at the committee?
Yeah, there was quite a lot of discussion. Just before I give my views on that, I'd just like to build on something that Stephen was just saying there about the uptick. There certainly is an uptick, and I know, and I'm sure Michael would have the same experience, that talking to different people involved in the insolvency industry, we do get the sense that there's a lot more interest in SBRs. More people are talking about it. Towards the start, there was a few firms, mostly in Victoria, that were doing it, and we're now seeing a lot more firms doing it, more practitioners taking more of them on, and we're seeing a pretty high success rate. To reflect back on voluntary administration, as you said at the start, I'm Dr. Harris now. I just got my PhD, and I feel I have to put that into every presentation. It took me 10 years. I'm going to milk it. And one of the things I did with that was actually track 5% of all the voluntary administrations from the first voluntary administration till the end of 2018. So I've actually got statistics on all the VA appointments over that 25-year period. And while the number of SBRs is much lower than the number of voluntary administrations in the first 2 years, where the SBRs do trump VAs on that early implementation period is in the agreement on a restructuring plan. So the DOCAs in most years are never going to be more than about 35% of the total number of VAs. And that's over that 25-year period. Whereas with the SBR, the report that you mentioned, I think the plan rate was about 70-80%.
78 plans out of the 82.
Yeah, so even higher. Yeah.
That's up to the 30.
Yeah, sure.
Yeah. So it does seem that major creditors, and in particular the ATO, is at least open to the idea that they're supportive of it. In terms of the question that you actually asked, what was the discussion amongst the committee and the hearings and the submissions? While there was a lot of support for streamlined and cost-effective measures for micro and small enterprises, there was a lot of criticism of SBR, and in particular about simplified liquidation. Now, I don't think we should necessarily group them together, even though they have the same eligibility criteria. But the criticism for both of them really was that they were still a little bit too complex, that even at the price point of about $22,000, that might still be too much for some small business, and maybe that we need some alternate mechanisms. Probably a measure that I could see the committee recommending, just because so many people recommended that they do it, was to recommend lifting the $1 million liability cap. Now, there were some, I think in particular the ATO and some of the creditor groups, who cautioned about that. They didn't reject it outright, but they cautioned about it. But there was a lot of support for saying that the $1 million is probably a bit too low, and it should be a little bit higher. And of course, the committee was very interested in the international experience. The streamlined insolvency and restructuring process in Singapore has a much higher threshold. The threshold in the United States is currently 7.5 million, although it is due to come back down to about 2.5 million next year. So the overseas examples are higher. So I think that is something that we could see. But trying to simplify it more, I mean, certainly I've been very critical of the drafting of the legislation in terms of just pretty much adopting the guts of voluntary administration. And if this is supposed to help small business that are, already starting from a pretty low asset base, I'm not sure that you need to include, which I actually said to the committee, 100 pages of rules and regulations to try and address this. I think we could have a much more streamlined process. But there was broad support for it if we can try and make it a bit more streamlined. And certainly thinking about the eligibility criteria, even aside from the debt threshold, but the requirement that you have to have all your tax lodgements up to date, and that you have to have your employee entitlements, outstanding liabilities paid. So on those 2 points, there were some who were asking for more clarification about the tax lodgements, because the legislation doesn't say all of them, it says substantial compliance. So there was some request for clarification on that. But on the employee entitlements, several submissions, and I can't remember if we said this, but certainly a lot of submissions said we maybe need a bit more flexibility on employee entitlements, because if you've fallen behind in your superannuation contributions, for example, and the reports that insolvency practitioners submit to ASIC show that in about half of all of the cases where the reports have been given to ASIC, there's outstanding super. So that means all those companies are automatically ineligible. So there was many suggestions that maybe we could have a provision where you can make up the employee contributions in the restructuring plan itself, rather than having to have them already satisfied. On the simplified liquidation, I don't recall seeing a submission that said that that was a great system. Of course, the statistics on the simplified liquidations are much lower than they are for SBRs. Several, including ARETA and I think also AIIP, said that it's really a misnomer. It's not a simplified liquidation. It's a more complicated liquidation than a standard liquidation. So there clearly needs to be some work on that one.
Perhaps just turning to a couple of the more technical issues.
Good.
Everybody okay? I was very interested to see in the list of submissions, number 78 was a submission by Badenoch Integrated Logging Proprietary. Now, for those of you who follow the cases in the High Court, that was the company that clarified the law of preferences and the continuing business relationship test and the peak indebtedness rule. And so my question, Michael, is what sort of focus was there at the committee on things such as preference recoveries? Was there considered to be a need to bring those into consideration?
Lindsay, I got a question like this from the committee, and I said, look, I'm very pleased to have sitting next to me Professor Harris, who would be far better to attend to the detail of that. And I will, if that's all right. But to talk about preferences, they're rather contentious issues, certainly from creditors' perspectives, in the sense that they've lost money already, and then they find this letter from the liquidator asking money for more. And there was talk about doing away with them or putting a threshold requirement in terms of their recovery. And those sort of things sort of exercise the mind of the committee. I don't particularly recall, and I will defer to Jason in terms of that particular issue that came. In fact, I don't really think, if I may, no disrespect to the committee at all, but that's not the sort of issue that it might properly be dealing with. It's far too detailed and legal, and it might be best left for a broader inquiry. But probably the real question is to the validity of preference law to start with. Is it fair? And how do you justify it? What caveats to put on it? I think that's the sort of thing that any law reform inquiry would be looking at. Do you remember the detail of that?
Well, I mean, there was several submissions from people who've been involved in preference cases, and I'd say that the overarching theme of them was that they did feel, and we might expect them to say this, that the preference regime was unfair. There were some, I thought, useful recommendations to consider around law reform. So as Michael said, things around the perhaps setting a minimum amount that you can, before you can take action. And that, of course, many people in the audience would recall the previous government had recommended some changes in that nature. There are a lot of recommendations around giving greater clarity on the defences, and the creditor groups were certainly very concerned that they might be supporting their debtors, trying to assist them to try and deal with their financial problems, but as part of their ordinary kind of credit management and those efforts, that they might then remove any possibility of having a defence under 588FG. And so there were many submissions. Just turn that off. Sorry about that. There were many submissions that suggested that there be some amendments to those defence provisions. There was also, and this really goes back to my initial point, there was also a lack of understanding about what it is that liquidators do in that particular space. So There was, for example, many creditors complained, well, we don't hear anything from the liquidators for years. And then kind of, a few days before the 3-year time limit, we received the court notices. And of course, the other side of that equation is, well, it's because there's a 3-year time limit. Like there's not a law that says you have to bring the action in the first 6 weeks or something. So part of that, having a better understanding, and of course, if the creditor might not be aware that actually the internal records of this particular business are a shambles. And so it's actually taken quite a lot to get to the point where the liquidator is able to identify who might be subject to recovery proceedings. So, but there were so many complaints about preferences, even from some insolvency practitioners, that I think that is an area where we might see some reform. Whether the committee would say, okay, yeah, let's have a threshold. Some recommended, for example, that preferences and indeed other voidables should only be available for related parties. Or in cases where there's actual knowledge or there's an actual intention to obtain a preference. So I can imagine the committee would recommend that be an area for reform, but I'm not sure whether the committee would be comfortable in coming, and I haven't seen the report either, but having a look at all those submissions, I'm not sure the committee would necessarily come out and say, well, that's it, nothing below $30,000 and only against related parties.
It'd be very difficult, I think, to ignore this, given that the previous government had gone to the point of almost legislating changes to unfair preferences, at least in terms of the amount involved. I have a question from Trevor Pobrowski, who asks, given the low numbers of safe harbour appointments, what is the panel view in relation to safe harbour being applied to SME, small, medium businesses, given most of the appointments are applicable to large and listed companies? And perhaps whilst we're on that topic, we might ask our panellists what coverage there was indeed of safe harbour at the committee.
Did you want to?
No, you go.
Okay. So safe harbour is really interesting. I'd say the overarching theme in the submissions and the comments before the committee were, why hasn't the government enacted the Treasury Safe Harbour report? Just do that. There were clearly some, and I would say mostly again in the building and construction, but also in the manufacturing industry, the submissions from unions generally expressed concern about safe harbour. There was a particular matter that actually got quite a lot of airplay during the committee hearings and then generated a lot of questions on notice to various government departments. And that was the restructuring using a creditor scheme of Avato, which apparently was a big printing company. And basically the union involved in that, the AMWU, but also the ACTU, had complained to the committee that essentially this was a director, because it was a sole director company, using safe harbour to rip off the workers, was essentially the allegation. And that they were saying one thing to the employees, trying to get them to agree to change their conditions, particularly around redundancy pay. And then they were expressing concern. At the same time, they were clothing themselves in this safe harbour to protect themselves. Now, I think actually ARETA, in their supplementary submission, they made two in the second supplementary submission, they did quite a good job of explaining why that view actually doesn't reflect what the law is. That the safe harbour, of course, as many in the audience would know, is only a defence against directors' liability for insolvent trading. So it's not completely irrelevant to employee entitlements because they could be subject to insolvent trading debts, but they're really quite separate issues. So I'm not sure that that's necessarily a good case study to say that the safe harbour isn't working. Now, the question Trevor actually asked about SMEs, lots of comments in the submissions that basically insolvent trading isn't at front of mind of business owners of particularly small and micro enterprises. And so, given that many of them have given personal guarantees in order to get external finance, and even aside from that, there's often an intermingling of personal and business finances, that insolvent trading is just not the top of their list, that they're worried about keeping a job, keeping a wage, staying in their home, not getting a divorce, the bank taking action rather than the potential for an insolvent trading action. And of course, coming back to criticism of ASIC, noting that ASIC has almost vacated this space. There's a couple of criminal cases ASIC hasn't run a civil insolvent trading case in about 15 years. So it didn't seem to be front of mind. Now, whether that means we should abolish it, if it's not being actively used at the micro and small end of the market, although of course we have no statistics about that because there isn't a register of safe harbours, we don't know. I know a couple of practitioners who work at the small end who tell me that they're actually doing quite a lot of safe harbour stuff, but there is a view, and this came through in the safe harbour report from their submissions, that it's not that relevant for the small end of town. But I don't know that that means we should get rid of it.
There's a comment from Eddie Musk pointing out that safe harbour is in fact available to small medium enterprises if they go into small business restructuring, because
yeah, of course,
the liability for insolvent trade is suspended throughout the period during which the directors are developing their plan and the supervision of the SPR.
And just on that issue, Lindsay, there were some creditor groups, so Institute of Credit Management, for example, who were actually complaining about that the directors can use a debtor in possession regime, go into an SBR, and creditors essentially are still on the hook, but the directors get protection from insolvent trading liability. So there were some suggestions that there should be a rethinking of the personal liability in that particular circumstance. And there was also concern about the potential for things like unfair preferences or other voidables if the SBR fails and that it ends up in a liquidation.
Do we have any questions from the audience in relation to some of those topics? If not, let me just stick with the technical floor just a little bit longer. I won't direct this to Michael because he'll only refer it to Dr. Harris. Trade trusts and insolvency. We had...
that was the question I got from the committee that I referred.
I'll definitely pose it to Dr. Harris. We had a good look at this in terms of submissions from the legal and insolvency practitioner industries when the previous government undertook its own inquiry in specific terms in relation to trade trusts. And that, of course, did not culminate in anything because of the change of government, but it was very much back on the agenda for the PJC. And so, Jason, I'm just wondering how much time was spent on that topic and whether or not they're going to be leveraging off the work that had already been done in seeking submissions on the topic.
Yeah, it's a great question, Lindsay. Going through the submissions, a lot of them said, look, Treasury's already consulted on this, and there were, 30 submissions or something that went in about a year or so ago into Treasury, which are all available on their website. Some of those are very detailed. So many of the submissions to this PJC basically said, we're attaching what we told Treasury a year ago. To try and summarise what those various submissions were suggesting, probably the most common complaint was really twofold. From insolvency practitioners and insolvency lawyers, the most common complaint was about the automatic removal of corporate trustees and the legal effect that has on the corporate trustees' power to deal with the trust assets. So the so-called ejection clause, and noting that the ipso facto changes that we had in 2019, of course, are not retrospective for existing contracts. So there's loads of trust deeds that were written before 2019, and so they're not covered by that. And of course, that also doesn't apply to liquidation. So that doesn't help there. So if you're then removed as a trustee automatically under the terms of the trust deed, then you're basically acting as a bare trustee, which means that you don't have the power under the terms of the trust deed to continue to deal with the asset. So legally, you're supposed to go off to the court and get the appointment of a receiver for sale. So a lot of people complained about that and said, this basically is a waste of money, often from the states that don't have a lot of money in the first place. I know certainly through the Ross Parsons Centre, we've run several webinars on this over the last couple of years, particularly leading into the High Court's Ameren case. So that was clearly an issue that needs to be resolved. Now, some were saying, just go back and implement the Harmer recommendations. There was a whole chapter on this, as you said, in the Harmer report. Others are saying, look, we can just change some of the sections in the Corporations Act to just make that even clearer. It was very clear that the Ameren decision in the High Court, Carter Holt Harvey, has helped in some way, but hasn't fixed the problem by any means. There were some very detailed submissions from very learned trust lawyers that were going into issues around the scope of a trustee's right of indemnity, how that might work, and why it's potentially unclear with respect to insolvency practitioner remuneration. claims. So there was some comment about that maybe we need a little bit more clarity on that. On the other side of things, on the creditor side of things, the submissions really were focused on the fact that it can be very difficult to know that you're dealing with a trustee and that there should be a register of trusts. So if the committee wanted to come out with some smallish recommendations, some clearish recommendations, I could see that being one of them, that the government should look at a register of trusts. Some of you would know the government is already looking at a register of beneficial interests, and there was an allocation in the recent budget to assist with that, although it was a tiny amount of money. So whether that will work or not, it's another matter. But they were two sides of the trust equation. For those in the audience who were really interested in this issue, there were several submissions that really took you through this from start to finish, were very detailed. Nuncio D'Angelo's submission, I can see one of his partners here in the audience, he basically said, here's the legislation that you need. And he essentially, through his submission, rewrote the law to address the issues. Hamilton and Morrison from Queensland also did that. They come up with their own suggestion. And then there are a few lawyers who put in their own suggestions about particular drafting. It is a horrendously complex issue. And I know, talking to my colleagues here who are professors of trust law, not trust insolvency law, they do tell me that any changes that we want to make to deal with the insolvency problem really do need to take place after we have a broad consultation about how that might affect other trusts, because not every trust is a trading trust. Not every trust is going to be incurring a lot of debt. And so if we say, well, all trusts have to be registered, is that going to be necessarily appropriate if it's a family trust, for example, if it's a testamentary trust? So there's a lot here. Dr. D'Angelo did qualify that by saying only trusts that are basically commercial trusts should be subject to this.
There's a comment from Eddie Mussett concerning frustration when court liquidation orders are sought and don't seek appointment as a court-appointed receiver. I think that's a fair comment certainly when it's known that the entity that's being put into liquidation is acting as a trustee of the trust. But sometimes, I'm sure there's people in the room who'll find when they're presented with an appointment that the first day you find that it's a trustee is when the directors say, oh, by the way, he's the trustee of our family trust. But to Eddie's point, I mean, one of those short, quick fixes that might be seen in this area, perhaps, Jason, is just a simple adjustment. Amend the Corporations Act to give a liquidator the power to deal with trust assets.
Yeah.
Was that covered by 30 years ago?
Yeah.
Could I just express a bit of frustration about that topic, trusts and also safe harbour? Before this inquiry, PJC inquiry was set up, each of those were well on their way to being resolved. Treasury had consulted widely in relation to trusts, and I think you said, Jason, they had a large number of very good submissions.
Yep.
The safe harbour report had been delivered and was awaiting implementation. And we're sitting here today and nothing has happened. And I happened to be at the committee when Treasury was giving evidence, and the committee itself asked Treasury and said, what has happened about the safe harbour reforms? What has happened about trusts? And Treasury said, oh, well, we can't do anything about those because this inquiry has been called and therefore we've got to wait for the outcome of this inquiry. Now, I sort of understand the sense of that, but it's only put off, and sort of caused this inquiry now to get all those submissions again and have another think about it. It's a very frustrating process. It's got to end.
Yep. Comment from Jim Johnson noting that the ABN, the Australian Business Number Register, could constitute a register of trusts, but that it doesn't identify the name of the current trustee.
And there were recommendations in some of the submissions to try and improve some of the disclosure, even aside from a register, but for example, maybe requiring, just as we have a requirement in the Corps Act that you've got to provide the ACN on public documents, then including a requirement, and if the company's acting as trustee, then you have to apply the relevant trust number.
We won't go into tonight because it is a bottomless pit, but PBSA, of course, raises this very specific issue in terms of who you identify the grantor as by ACN or ABN. And we've seen these amazing cases where securities that have been purportedly taken from a company using its ACN are rendered worthless simply because of the mistaken belief that they weren't dealing with a trustee, in which case the PBSA requires registration by reference to the AB. So Again, I think that was something that PDSA was in fact one of the terms of reference for the inquiry, and no doubt we'll see some more on that.
And there was general frustration across the board in the submissions and in the hearings as to why the government had not acted on the Whittaker report. I mean, there was a wholesale review of the PPS, which was conducted by Bruce Whittaker all the way back in 2014, 2015, and it's just been sitting there for 7 years. And when really pressed on this, essentially Attorney General said, well, you know, we've done little things here and there, but there was no sense that there was some, you know, there hasn't even been a government response to that report. So, sorry?
3 years.
Yeah. Yeah. Yeah.
For the benefit of those online, some discussion here about the effect of COVID on restricting or retarding amendments to the law in this area, and pointing to the fact that there was a period of time before COVID hit. It was something that had been done.
Can we talk about?
You can talk about COVID indeed.
The liquidator is actually changed space.
Okay, just wait a moment. We'll get you to have the microphone.
And it's sort of a reform that was brought on us by happen chance, but it certainly streamlined a lot of things that we do as liquidators and I guess trustees. The virtual meetings have certainly superseded any of the old-fashioned meetings when creditors have turned up physically in a room. The reporting systems that we've got now with emails have pretty much reduced to nothing the old postal addresses. And it brought in every office in Australia who's not paperless. They can't possibly run a insolvency practice now without engaging with the new technology. And it was part of AIP's submission too, to also consider what communication system the next generation of liquidators will be looking at, and the adoption of things like apps and the adoption of smarter technology about how we communicate with people. Michael's got his own paper on it, 2017. We talk about his review of Scandinavian countries of where companies are parked in the space of virtual reality and why we can't get there ourselves. We're spending a lot of money in Australia on this, the new business registry service, which is taking up, interesting, it doesn't take up SBR, it doesn't take up personal property security, they've left that out, but all the other registries are being taken up. And this is an enormous opportunity for the government to look at how business is done and how we can communicate through apps and through platforms, rather than this concepts of rounding up all the information that we need as liquidators, and it's all there on one platform, whether that's called a My Company or a My Biz, as the Senator made a joke with me when I made that little submission. But I think this is where we're going, and when you've got an app that holds all the data of the company, its bank, its assets, its filings with courts, and then a liquidator is appointed, he can take that app, or he or she can take that app over and then communicate with the creditors because the information's already there. So if we're going to be productivity driven, I think this is a space that we should not research.
Not to mention the intrusion of artificial intelligence.
Well, absolutely. Yeah, but the cumbersome way that we have to conduct liquidations today, you'd be staggered. You write letters to ATO and wait for them to give you the passcodes to get into the account so you can start your investigation. You write to banks, but why are we waiting so long to get our hands on the information that we need? And we're all talking apps now, aren't we? We're all talking smartphones, talking to each other. So we eventually get there. But I think it's a great time to think of seriously now. The money's being spent on other services, but now's the money, just time to spend it on that. That's my end.
Would be nice, wouldn't it, to be able to dial up ChatGPT and say, please write me a report to creditors in relation to the following administration.
We've been doing it.
And is it working?
We're not as smart.
Can I just add a further comment on that? Just to build on what you're saying there. One of the themes that came through a number of the submissions and in particular in the hearings was the inconsistent use of data across the system. The lack of data, the poor state of statistics that we get out of both sets of regulators. Well, in some areas they're improving. We're getting some improved reports. But there were many times the committee would ask people hearing before it in the hearing, saying, well, what evidence have you got for this? What data have you got for this? And the answer invariably was, well, we don't, particularly of the government departments. Now, Michael and I, in our submission, and indeed in what we said to the committee in our opening statement, some of the stuff that ASIC put in their submissions and responses to questions on notice, some of the stuff that the ATO put in, that the FEG program put in, was fantastic data. And our question was, why don't we see this more often? Why is it the only time we get quality data is when there's an inquiry? These are the sorts of things that we should be seeing more often so that we can properly evaluate how the system is working. And that was one of the things I said to the committee is we actually don't know how the system is working because mostly the data we get from ASIC is how many companies go in and how many appointments there are. And that's kind of it. So we need much better data and linking it up with the technology.
Yes, David.
I wonder whether we can speak about diversity and particularly women in the profession.
Mm-hmm.
And one of the things that was covered at the inquiry was the difficulty in women being able to meet the prerequisites, particularly if they were on maternity leave successive times. Do you want to speak to that, please?
Yeah, sure. I mean, I'd start, I guess, at the broader level. Diversity was an issue that was raised by a number of firms, mostly from insolvency associations and also insolvency practices, raised that as an issue. I mean, the point that you mentioned about the number of hours of senior management experience you need in order to get your ticket as a liquidator was cited as being problematic for people who take extended periods of leave, and that could include maternity leave, for example. But I think diversity is a broader issue as well, even aside from the number of female registered liquidators and female registered trustees. Diversity in the profession was a bigger issue. I mean, KPMG had some really good discussion on that. ARETA certainly had some good discussion on that in their submission, AIIP in their submission. So,
and TMA.
And the Turnaround Management Association, yes, they had quite a detailed discussion of those issues. So again, I'm not sure that that's something that the committee would come out and say, oh, well, it's 4,000 hours now, let's make it 2,000 hours, or let's allow for a longer period of time to accumulate that so that we can accommodate these issues. I think that the committee would probably come out and say, yes, this is an issue. Numerous different stakeholders from both sides are telling us this is an issue. It warrants further investigation as part of a broader review.
I thought that the committee was motivated to do something about it.
Okay.
They were motivated to do something about it. I thought that I was there on the day that the TMA presented.
Right.
They were very compelling. So we'll watch this space.
Yeah.
But they need to do something more. In other jurisdictions, for the number of hours they require in Australia, the regime we have in Australia, the TMA indicated that it's more than in other jurisdictions.
Right.
Have you any observations on that?
I can say, I think, from knowledge that New Zealand is either 1,000 or 2,000, depending on your particular membership. And in the UK, it's 600 hours.
Oh, wow.
Have any other criteria beyond ours? Because
there are other criteria, but I'm just saying that experience criterion is far less in other countries. 4,000 is a very large number of hours to meet in Australia.
Comment from Catherine Robinson on this topic. I've asked this of the regulators, a non-legislative way could be to issue some guidance for people on career carers, maternity leave, etc., on how they might comply with these registration requirements. The committees have power to add conditions on registration too if they don't meet the requirements. Earlier comment from Eddie on the position of the ATO and the use of director penalty notices, fundamentally changing the liquidation process, which I think is a nice segue into asking our panellists about the ATO and what examination was undertaken by the committee in relation to the position of the ATO.
I found this one of the more interesting aspects of this process because the ATO appeared before the Commission. They put in a reasonably detailed submission setting out, their approaches and their policies. They provided some useful statistics. They were subject to the second highest number of questions on notice. So they put in about 18 responses to different questions on notice. ASIC had the highest number. They had 28 separate responses to questions on notice. But it was, from my perspective as an external observer, it was fascinating to see the disconnect between the various parties. Because to try and broadly summarise what the ATO was saying was, look, we're just a regular creditor. Of course, we're involved in all these insolvencies. We're often one of the larger creditors, but, we're just a creditor and we just want to get paid. And, okay, we have these other powers and we exercise them where we need to, but, we're just a creditor. And they actually made a statement where they said, we're actually not that significant in terms of company liquidations, that, it's only a small number of companies that we wind up. So then several submissions, the one that I'd particularly point out was Michael Brennan's submission number 73, and he completely deconstructed that argument with his own statistics, because his firm keeps statistics on liquidations in Queensland, showing that the ATO is actually a major creditor who seeks court winding up. Yeah. And the submissions on the other side were almost universally critical of the ATO, and they criticised them in a number of different ways. One of the ways was, and I think this is perhaps the most important, was to say it's actually unclear what the ATO is trying to achieve. So some submissions said, if they're just a creditor, and the reader submission would fall into this category, if they're just a creditor, why do they have all these extra powers? And if they're just a creditor, why do they have powers that, when they're exercised, are actually inconsistent with the goals of insolvency and in particular restructuring? So there was some submission saying, if you just want to be a creditor, then just be a creditor and don't have all these extra powers, which can undermine what we're trying to achieve, particularly when you're trying to save a business. On the other side of things, there were several insolvency submissions from insolvency practitioners that were saying the ATO can be uncommercial and can be very inconsistent in its approach. So some said, you can get a different response depending on what day or who you might happen to speak to. There were many submissions that actually said it's becoming increasingly more difficult to actually speak to someone at the ATO. That if your debt is, less than 100,000 or something, you're basically forced through a telephone system. Some put in submissions saying the only way that they can actually get a response out of the ATO is to lodge a formal complaint. And that then takes them out of the standard ATO system and puts them in a separate complaint system where there are timeframes that they have to meet. But there was overwhelming criticism of basically what you were saying before, Stephen, about the timeframes just not being realistic and not being commercial in insolvency proceedings. So, I'd say that the ATO, I can imagine they will get criticised in the final report.
Hi, Jason. The ATO is very understaffed. I'm not from the ATO, but I deal with them regularly. I make my own phone calls with the various officers. And what I found over my career is that when they used to have a carriage of a file, it was far better than the simple, let's pick up the next creditor's correspondence out of a tray. But they can be very commercial.
Yep.
And, some of the criticism, I think, is a little bit unfair. If you bother to take the time as the practitioner, you'll always get a response from him.
And I would also just add, just from my own experience during my PhD studies, I asked people in interviews, as I interviewed 40 stakeholders and asked them about their experience with the ATO. And I particularly put these questions to them. Some people have said the ATO is very uncommercial. And I had plenty of lawyers, insolvency practitioners and some creditors who said exactly what you're saying, that they can be very commercial. It's not a case of the ATO being institutionally uncommercial or difficult. It's a big organisation. They're a creditor in pretty much every one of these cases. And as you say, they've got very limited resources. And that was very clear in their appearance before the committee, that they don't have the resources to be the most active creditor in every single insolvency in Australia.
They lost them during COVID, apparently.
Right.
Well, look, there is a comment from Zohar Hosseini, which leads, I think, in very nicely to the last topic I think we should try to look at tonight. And Zohar says, can we expect any reforms or further inquiry from the PJC in respect of protection of employee entitlements and wages after an insolvency event has occurred? The commercial arrangements may result in reduction of those entitlements, the debt factoring arrangements. So perhaps adding on to that, I understand that there were a lot of submissions in relation to the role of the Fair Entitlements Guarantee organisation. So what do you think might come out of the inquiry in relation to the position of employees?
So the role of FEG in insolvency was criticised again from really both sides of the equation. So on the employee side, we had various large unions who heavily criticised the current system for not including superannuation. They also criticised it for capping certain amounts and highlighted certain areas where statutory entitlements aren't adequately covered by the current regime. So that was one criticism. On the other side of the equation, in terms of insolvency practitioners, the criticism was that FEG was, again, not being a regular creditor. And I'm sure there would be many insolvency practitioners who say that FEG can be incredibly useful in insolvency because they are notionally an active creditor. Their program is called the Active Creditor Program. And they can provide funding where other bodies like the ATO or other major creditor groups are reluctant to do so. So they can be very useful. But there were multiple criticisms from several different firms and several different practitioners who said that they had had a very difficult time with FEG, and that FEG had taken is taking a particular view about the use of circulating assets for trading on a business, and that was causing problems in terms of trying to influence insolvency practitioners about their trade-on decisions, and that was perhaps producing adverse outcomes in things like voluntary administration. One of the points which came up several times was that FEG would use its financial muscle and its information gathering powers to basically go well beyond a practitioner's current file, perhaps to try and pressure them into basically agreeing with FEG's view about what should be done with the circulating assets. So I could imagine that the committee may well recommend that there be some further guidance. There were recommendations in many of the submissions that FEG basically should be a model litigant, or there should be some sort of model creditor policy that applies to FEG and the ATO to stop some of these things. I've said for many years, as a bit of a hobby horse of mine, that I don't think FEG should have its extraordinary information gathering powers that no other creditor has, that are not subject to a reasonableness threshold. And that does clearly seem to be causing a problem for many practitioners.
Any comments in relation to that? Because I think we see so much litigation in this space where FEG is in fact the moving party. We've seen a lot of the issues concerning circulating assets going to court for sometimes rather ambitious interpretations of the provisions in the Act. I know there was a recent case involving Section 551, which came before Justice Black. I think that was a fair funded case, and the judge wasn't interested in the argument in relation to that. They did.
In fact, lost out in that.
So it's a very interesting area, and we will have to just wait and see, ladies and gentlemen, because the report is due to be handed down by the 30th of May. I haven't heard anything about requests for extensions of time. I think the committee, from all reports, has been extremely diligent in the way that it's gone about the process, and I would certainly expect them to, if they can, meet the deadline that the Parliament has imposed. Yeah, Mike, did you have a comment?
Just one final comment, if I may, from a personal insolvency perspective. Of course, this was only focused on corporate insolvency, but inevitably, personal insolvency came up in the SME space, and the committee sort of acknowledged its limitations in commenting on that. But in the meantime, the Attorney General had what was called a round table on personal insolvency. This is about a month ago, where personal insolvency reforms were considered. And some of the comments that came out of that from the transcript of what was determined that day were that, personal insolvency would look to see what came out of this corporate insolvency report in terms of any, I suppose, holistic approach to a reform of the insolvency system. He wouldn't certainly do one without the other.
Well, ladies and gentlemen, that concludes the formal part of the session tonight, and I'd just like to ask David Levi on behalf of AID to make some closing remarks. Thank you.
Well, thank you very much. I'm David Levi. I represent the AIIP tonight. It's the Association of Independent Insolvency Practitioners. I also thank the Parliamentary Joint Committee and particularly Senator Deborah O'Neill. The AIIP presented before Senator O'Neill, myself, and also Stephen Hathaway, and we put together submissions. It was great to be there, and the approach of Senator O'Neill was extremely robust. And to read the transcript in relation to the Treasury, ASRC, ATO, I was reading the transcript at 1 o'clock in the morning, and my wife came down to say, "What are you laughing about at 1 o'clock in the morning?" And so well worthwhile to read some of those transcripts. It will bring about change, and I'm satisfied that it will bring around change. The ARP is delighted to have provided a commission, including financial assistance, for the conduct of this research to the University of Sydney Law School and also Ross Parsons Centre. The project leader has been Dr. Jason Harris, and I'm delighted that you had your graduation ceremony just recently, so post-COVID. Professor of Corporate Law, the University of Sydney Law School. He's been assisted by student researchers, and they are Jesse Nikolakakis, Jerry Toe, Julia Tran, Kim Newen, and also Lisa Allen. So I thank each of them, and it's been a great opportunity. So I extend thanks also to Michael Murray, and Michael is the co-author with Jason Harris on the leading textbook, Key Insolvency, Personal and Corporate Law and Practice. Lindsay indicated in his introduction the other roles that Michael has within the professional community and elsewhere, and it is great to have him involved, and thank you for attending today. And also I extend thanks to Lindsay Powers, that senior legal consultant, Minter Ellison, a lawyer I've known for many years, and the adjunct associate professor, University of Sydney Law School. The Association of Independent Insolvency Practitioners, AIIP, or www.aiip.org.au, is a non-profit organisation established by registered liquidators and trustees in bankruptcy to assist fellow practitioners to meet the challenges prevailing in the profession. AIIP was founded in 2016, indeed by Stephen Hathaway, who's just stepped down as our president after 5 years. And I note that about 1/3 of all registered liquidators in Australia are members of AIIP. The members are either registered liquidators and or registered trustees in bankruptcy. AIIP members practice primarily in the SME space. We operate nationally, and we have our 4th National Annual Conference at the Hyatt in Canberra on 13 to 14 July. Our keynote speaker indeed will be Senator Deborah O'Neill, who is the chair of the Parliamentary Joint Commission, Inquiry into Insolvency. We'll also have a panel discussion which includes the very eminent Dr. Harris and also other eminent guests. So again, thank you very much.